friends, today we are going to see a Supreme Court ruling in the case of M.S Ananthamurthy versus J. Manjula. So this ruling gives us the idea about the legal implications relating to property transactions executed through a general power of attorney and agreement to sell. So welcome to RT's Tax Info. The dispute centered around the validity of the property sale executed by Saraswati, who held the notarized irrevocable general power of attorney and agreement to sell from the original owner. The original owner died during 1997 and Saraswati sold the property to her son during 1998. Subsequently, Manjula, claiming ownership through registered sale deed from another party, filed a suit against Ananthamurthy, who originally acquired this property from Saraswati. So what is the legal issue here? The primary issue before the court was whether general power of attorney and agreement to sell has given Saraswati the power to execute the sale deed even after original owner's death. So what is Supreme Court ruling? No transfer of ownership. Even when you held the general power of attorney along with agreement to sell, there is no ownership or title transfer happening in this. Hence, only the power of attorney and agreement to sell does not transfer any title to the assessee and it does not equate with the original or registered sale deed. Revocability of power of attorney. The mere inclusion of the term irrevocable does not render the general power of attorney as irrevocable. So, the nature and scope of the power of attorney is determined by the subject matter. Termination upon principal's death. The power of attorney is inherently terminated upon the original owner's death unless there is an agency coupled with interest. So, in this case, the Saraswati does not have any interest mentioned in the power of attorney. Hence, this automatically stands terminated and hence the sale deed executed by Saraswati for the sale of property to her son is not valid. So the Supreme Court decision tells that for the property to be legally valid, there should be a registered sale deed. Only the general power of attorney with the term irrevocable mentioned therein and agreement to sell does not form part of the legal documentation for the transfer of ownership or the title. Also, such power of attorney automatically gets revoked upon the death of the original owner. So this ruling reinforces the legal principle that execution of proper sale deed is required for the transfer of the ownership or the title for the property transactions. And also, the parties should abide by the statutory requirements to safeguard their property rights. So if you have any doubts with respect to this video, please mention in the comment section. Thank you.